Zelda's early this evening. Hello everyone, and welcome to another What Your Builder Doesn't Want You to Know. Thank you ever so much for joining us. I'll just check the time, and the official time is 6:29, so we'll just wait a few moments before we make a start proper. But this evening we're going to be talking about the Consumer Rights Act and how it pertains to a contract with a builder or a tradesman. A lot of builders certainly wouldn't want you to know your rights. That's not to say everybody's a cowboy builder, because a lot of builders are certainly not. But if you know what your rights are going in, then you're best placed to protect yourself. As always, I would love it if you get anything out of these videos, if you could like, share, subscribe. If you're watching on Facebook Live, fantastic. If you're watching on YouTube, fantastic too. If you know someone else that you think would benefit from some of the information we're talking about, please share it. It'd be very much appreciated. So, because we're talking about some legally stuff this evening, it's really important. I just want to say I'm not a lawyer. I don't pretend to be a lawyer. What I'm doing is I'm trying to give you the information I have for you to do whatever is best for you with it. But you should always obviously seek independent legal advice of your own. So, as of October the 1st, 2015, the current Consumer Rights Act came into place, and there were some changes within it that affected specifically tradespeople. So now you're quite heavily protected as a client, consumer, someone who uses tradespeople, contractors to do work. You're entering a contract with them, which is governed by the Consumer Rights Act. So, as I've said previously on some of the other episodes, and if you haven't seen them, please go back and have a look. When you're choosing your builder, it's really important that you choose a builder that you can communicate well with, because you're entering into a contract that's based on the communication that you've had with them up until that point. Good communication will A, prevent a hell of a lot of problems coming up in the first place, and B, should there be a problem, communication is always the first port of call to resolving it. So, if you've got a builder that you're happy to communicate with, that you've got a good channel of communication already open going forward, going into the contract, you're far less likely to have a problem, and you're far more likely to be able to resolve it without it getting difficult, should there be one. So you're entering into a contract. So what is your contract? Your contract is everything that's being discussed, be it verbally or in writing, that you take to understand as what's going to happen. Now, when you go and get your hair cut, you enter into a contract with the hairdresser. There'll be a price list on the wall. You'll say, I want a trim, and you've then formed a verbal contract. They're going to perform this service to the expected standard for the expected cost. And any deviation from that is a breach of contract, and that's covered by law in the shape of the Consumer Rights Act. So what's in your contract? Well, your contract, if you've done everything that I suggested in the previous episodes when we were talking about the difference between a quote and an estimate and choosing your builder, you've already got your contract in writing. Now, your contract doesn't have to be a piece of paper with building contract written on it and then the terms of the contract signed and dated at the bottom. Not that there's anything wrong with them at all, but your contract can be the email conversation you've had where you're discussing products, where you're discussing the remit of the work. It certainly would include the quotation, which would have an itemised specification of works. All these documents form your contract. So, that just reinforces what I've said previously about the importance of doing those things. Now, generally speaking, the problems that may come up that would lead you to wanting to refer to the Consumer Rights Act will, broadly speaking, fall into one of three categories. They would be poor workmanship, the work being done just wasn't as agreed, or the cost being far higher than was expected. So broadly speaking, most things can come under one of those three categories. So I'm going to briefly talk about each one. We'll start with poor workmanship. Now, the Consumer Rights Act is both specific and vague in this regard. It says quite specifically that reasonable care and skill must be employed, and it also says that the work done must be worth the amount charged. Now, my personal feeling is that it's been deliberately vague there to stop spurious claims. What I mean by that is, if as a contractor I come to see you, we have a discussion, being me, I would make sure this was all documented in my quotation, but you decided that you didn't want the best possible job, you wanted the cheapest possible job to serve a purpose, which can be quite a legitimate thing to want depending on what it is you're trying to achieve. I would make that clear in my quotation that, you know, we haven't done the best thing we can because that's not what you wanted. We've done the cheapest thing we can. Now, of course, what I'd like to do is the best thing possible. That would be a completely different quote, and it would have a different price tag. And as you can see, those two different elements would set the bar very differently insofar as what would be deemed to be reasonable care and skill. So, you know, reasonable care and skill, when you're having a Rolls-Royce job, you expect your lawn to be bowling green flat and you expect to pay for that. But if all you want is someone to throw some grass seed on the earth, then that's a different job, different price tag, a different level of reasonable care and skill should be expected. Now, this is my interpretation, so by all means, if you feel I'm getting it wrong, then let me know. But I'm fairly confident that that ambiguity was sort of written into the Consumer Rights Act deliberately. And the remedies for poor workmanship, when the workmanship's been done without reasonable care and skill that doesn't justify the cost, in the first instance, is to offer the tradesman the chance to correct it, particularly if they supplied the materials. That really should be the first port of call. If you provided the materials and they were a labour only, the first port of call may well be just a refund and to stop them in their tracks. Obviously, at this point, you may be left with a situation where you need to spend more than the original quote to put things right. So we'll get on to that a bit later. But any out-of-pocket expenses you can be reasonably expected to claim. The next type of problem would be work done not as agreed. So you've asked for a piece of decking as part of your landscaping work, and the builder has put down gravel. Well, that's clearly not as agreed, and if you've done everything sort of sensibly up till this point, it'd be quite easy to show that that's not what was agreed because it will be in the specification of works. Obviously, if you've got a verbal agreement, then the burden of proof that what's been done is not what was agreed is that much more difficult to meet. So it's just another example of why it's important to get as much detail written down as possible. And the recourse here is to say to the tradesperson, you know, you've breached the contract and you need to effect a repair or alteration at your own cost. And again, they should get a chance to put that right. The third item of frequent problems is unexpected rises in the cost. Now, I'm going to separate this out into two categories, and if you haven't seen the difference between a quote and an estimate talk I did, I strongly recommend you have a look at that next, because you're in a far, far stronger position with a quotation than you are with an estimate. So if the cost has risen more than you expect, with a quotation, you're on quite firm ground. Now, with a quotation, the cost cannot rise. By law, you are protected, and the cost cannot rise unless there were extras that you were informed of and agreed upon as they went along, or the quote was obviously a mistake. So there is no, the term obviously isn't legally defined in the Consumer Rights Act. So there is some wriggle room there for both parties. But ultimately, if I quoted to build you a 2-storey extension with 2 bedrooms upstairs and a kitchen, and my quotation said it was going to cost £250, that's clearly an error. If my quotation said it was going to cost £120,000, and halfway through the job I said, oh no, that was a mistake, it should have been £140,000, that's not obviously an error that you as the client could reasonably have assumed was an error. So if a builder makes an error that wasn't obvious, and this could be an error in their pricing, not necessarily a typo of the type I've been discussing, then ultimately the same rules apply to them as do to supermarkets. If you go into a supermarket and something is displayed at a certain price, they have to, according to the Consumer Rights Act, sell it at that price. They cannot charge you more than that. And if they can't satisfy you as to why you should be happy to pay these extra costs, then the course of action is very, very simple. You just say, I'm only happy to pay the quoted amount, and you explain your reasons why. And I strongly suggest you do that in writing, in an email or whatever, because should it escalate, it's really useful to be able to show I was quite prepared to pay the amount of the quote. I'm not being unreasonable. It's quite a good thing to have. The second set of problems is if it was an estimate. Now, if the price you were given was an estimate, the Consumer Rights Act purely says that the price you pay should be reasonable, and there's no definition of what reasonable means in this term. So anything beyond the control of the tradesman, such as fluctuating costs of materials, poor weather, anything like that, can be used as a reasonable grounds to increase the price. Strictly speaking, we should say as a reasonable grounds to alter the price, but I don't know many that would use those as reasons to reduce it, so I'm going to say reasons to increase the price. And of course, if it's an estimate, it's going to be much, much harder for you to say that the price has gone up by an unreasonable amount. So your recourse is still the same. If you believe it is unreasonable, you say, I'm only happy to pay the quoted amount, or what I believe to be a reasonable amount. So, to summarise briefly, you've got poor workmanship and things not being done as they agreed. In each case, really, the tradesman should get at least one attempt to put it right. I believe, although I'm willing to be corrected on this, that the Consumer Rights Act says they're allowed one chance to put it right. Obviously, you can give them more, and possibly a refund if you would prefer to go that route. So if there's a dispute, that's the first step towards resolution. The second would be to go to an arbitration committee if they're a member of a trading body or whatever. There might be some form of arbitration. It's also worth looking in your contract or in their terms and conditions, because they might set out what to do in case of dispute, and they have to be fair. So another thing is the terms and conditions must be fair and clear and transparent and use normal English language. If a part of someone's terms and conditions are deemed to be unfair, that is a breach of your legal rights as well. So it's worth knowing that. You may decide that some compensation is to be awarded for who knows what, particularly if you've got out-of-pocket expenses. That's something that must be agreed by both parties. If both parties can come to an agreement, fantastic. And the Consumer Rights Act does say that if compensation is to be agreed, it must be paid within 14 days. So you might get to a point where you've told someone to stop work and you've given them a lump sum payment up front, which you shouldn't do, at least not a significant amount. Please see my talk on why your builder shouldn't need money up front. And you may find yourself in a position where you feel you're owed money. So if you can agree that, great. Another reason why you should be dealing with a builder that you've got a good communication with already going in. If not, the next steps are to go to arbitration and then ultimately the courts. That'll be a whole nother talk another time. Another thing to bear in mind is that your claim will be with your contractor. Your contract is with the person you made it with. So if they subcontract out parts or all of the work, you've got no recourse against those subcontractors. Your recourse is against your contractor. So it makes things slightly easier if the person you instruct is using their own staff or doing the work themselves. I haven't got a lot else to say on this, so I will just repeat what I said at the start. And if you found this useful or any of my other talks, please share them. Please like us on Facebook. Please share us on Facebook. Please subscribe on YouTube. And I'll just finish up with a couple of small points. If anyone's done any work on your property and it's dangerous or unsafe, then you should report them to trading standards as well. I'll just hammer home the point one last time about how important it is to get things written down. Should you ever end up in court, evidence of what your contract is far easier to prove if it's in black and white between you and the other party than if it was just a discussion. And also, just to mention that the Consumer Rights Act, your rights as a consumer trump the terms and conditions of whoever you're dealing with. So they might have something in their terms and conditions that says that their defect liability period is a certain number of weeks, and after that time, any repairs or remedial work is chargeable. That may be the case, but if that disagrees with the Consumer Rights Act, who are quite explicit about the time periods for different things, be they products, services, then the Consumer Rights Act trumps the terms and conditions, i.e. if they say we're only going to look after that, for 2 weeks, and the Consumer Rights Act says that you have 6 months worth of recourse, then you've got 6 months. It is worth having a look around. There's so much on this subject, and a lot of it is nitty-gritty stuff. So I do strongly recommend that you have a look on the Which website if you want any more information or want to go into any more detail, and also the Citizens Advice website, both of which have excellent resources on this subject. So that's me done for tonight. Thank you very much. Next week we're going to be talking to you on a different subject: what your builder doesn't want you to know, why your builder doesn't call you back. I'm sure you've all been wondering. Find out next week. Thank you very much.